Hi, my name is Cliff Muncy. I'm a representative of Forsyth County for the de jure state of North Carolina, the North Carolina American Republic. And I'm here with John Ainsworth. He's Chief Magistrate of the Republic, and he's going to give us a little information about a case that we're going through here lately. John, we've got some papers here. Just explain first of all, tell me exactly what is the mission of the North Carolina American Republic, and how do we go about accomplishing that mission?
Well, the mission of the North Carolina American Republic is to get America back under lawful government. We got a huge movement out in the country today of like, how come we don't have states' rights? You know, how did the federal government get unlimited powers to where it can do all sorts of things? And we teach people, well, how did that happen? And it's actually a legal argument that has never been taken to court and adjudicated of how this happened. And most people don't know what this legal argument is. And of course, we take it back to Reconstruction. So our mission statement is to get lawful government reestablished back in America. And if you reestablish lawful government, you get back to local self-government at the state level. And you put the federal government back in its 10-mile square with limited powers. So it's really just restructuring, get America back to what our founders put in place and what was destroyed by the Reconstruction Acts of 1867.
Just to bring it up to modern day terms, how are you? So you're fighting. We're fighting Reconstruction,
right?
And so how do we go about doing that? I mean, tell me a little bit about the case that we have currently pending.
Our issue is a legal issue. Mm-hmm. Okay. And so we have people that go in and fight in court to try to bring up this legal issue so that we can get it adjudicated. Is the state that was brought into the American Union lawful? This new state called North Carolina that came into the Union June 25th, 1868, was it lawful? Well, we feel we have a right to challenge this. And so we've got an individual who has she's got a pretty good knack for getting tickets, Mandy Rose, and she goes into court. And the issue is she has realized that the state that's in place now is put in place by coercion and fraud and constitutional violations. It's unconstitutional, and it is not the original state being readmitted into the Union. It's the creation of a new state. So she's going into court. She's not wearing her seatbelt. She let her driver's license expire, and she's saying, you know what? I'll obey every one of your laws if you can prove you're a lawfully created state. The foundation of all law, the foundation of all jurisdictions is a lawfully provable jurisdiction. Your creation. Let's look at your foundation. But what we have here in the state is the state likes to start in the middle of the argument. They want to start with, well, we're lawful, so therefore you have to obey us. And we're like, well, that's an assumption, knowing you're lawful. So we're challenging the assumption of your lawfulness based on the unconstitutionality of Reconstruction, the annulment of the original state. And so Mandy is going in fighting this. It's a legal argument.
They have a responsibility to prove that?
Well, according to, all law is founded on, again, all laws of courts of justice are founded upon the concept of you have a lawful jurisdiction. Okay, that's the basic fundamental foundation. And that's the foundation we're attacking. That's the foundation Amanda Rose is attacking with the state. Mm-hmm. Prove your lawfulness, and then we'll talk about the seatbelt issues. We'll talk about all this other. Because I have no obligation to an entity that's exercising power that refuses to prove it's lawful. I mean, I do not have that obligation. No one has that obligation. Because that's just being bullied into obedience.
Now let me clarify something, because I think a lot of people that see these videos, they do misunderstand this. I want to go into this just a little bit. Most people have driver's licenses. The majority of people that drive, they have driver's licenses. Mm-hmm. And they obey the traffic laws and the speed limits. And so, isn't that stuff there for a reason? Don't we need that stuff?
Well, the answer to that is no, we don't. There are certain things you do need. Mm-hmm. Okay, you don't want just anybody going out there running around doing whatever you can. We're going to get into a little bit of international law here, concepts first of all, but we need to have certain regulations. But let's go to a driver's license. Okay, what is a license? A license is permission to do something which is otherwise illegal. Okay, so they're saying it's illegal to drive. It's illegal in the United States of America, in all 50 states, to drive a vehicle. Okay, And you have to get permission from the state. You know, they will tell you that driving is a privilege, not a right. Well, wait a second. This is the land of the free. You're trying to tell me that people don't have a right to travel? Well, this is kind of a huge issue. Now, we don't have a problem with certifying people's ability to drive competently. You know, do a driver's certification, because a certification doesn't infer that it's illegal, that you're doing an otherwise illegal activity. It's just showing you're competent to do, you know, whatever everyone else should have a competence to do if they're out on the highways. And then you go to the speed limits and the seatbelt laws and things of this nature. Well, there's a lot of these things that are designed for your safety. But the issue is, again, it gets down to the point of, can the state demand you be safe, call it a free society, and penalize you if you don't act in what they deem to be a safe manner? Okay? Because if you go under the common law, you know, the laws we used to have, you're responsible for your actions. So if you go out there and act recklessly and wreck somebody's car, you're liable. Okay, so you still have the liability. The law,
under the full extent of the law.
And people have a right to collect. If you injure them, you know, they would just sue you. People start taking people's property. Okay, because like, hey, you wrecked into my car. You don't have the money for it. I'm going to take your house. I mean, so there is remedy under these. You know, if you damage someone, but the issue is that we have now is, they're giving tickets and writing things on a behavior that could be deemed unsafe. Not that it is unsafe, but they could be deemed. This is why the police, and a lot of times rightfully so, get accused of writing tickets to generate revenue. Now, they're going to constantly say, well, oh, this is to keep our highways safe. But, you know, there's still accidents out there. You know, they can't stop accidents. I think if people were held more accountable to when they have accidents, be held more accountable than just, well, I got my insurance premium. You know, that's kind of a painless way. But go back to the old school where the people would come after you rather than your insurance company.
Personal
responsibility is what it boils down to.
I see. Okay. Well, tell me a little bit more about this case here that we have going through.
Okay, Mandy Rose, not wearing her seatbelt. Her basic argument is.
Who is this Mandy Rose?
Mandy Rose is a feisty little lady who's up here in the Winston-Salem area.
Okay.
And she is motivated. She sees the rightness of this cause, and has decided to exercise her rights to be a citizen of a lawful state, a state that can prove its lawfulness.
So she's a member of the NCAR?
Well, yeah, I know you're throwing the member thing out. We do not have members. There's no such thing as a member of the NCAR. We have citizens.
Okay.
This is the lawful state government. She votes, she pays taxes, she recognizes the original state, called the state of North Carolina, as being lawfully created, declaring its independence on May 20th, 1775 with the Mecklenburg Declaration of Independence, banding together with the other 12 colonies to do the Declaration of Independence, getting its own constitution December 18th, 1776. So she recognizes that entity and that body politic as being a lawful state. And she wants to participate in that. And that's how we're going to get America back. If people will do what Mandy has done, is to get educated on what's going on and say, you know what, I'm going to exercise my rights. The reason we don't have lawful government in this country is because I'm not participating in it.
So it's in the hands of the people.
It's absolutely in the hands of the people.
You mean it's not in the hands of the politicians?
It is not in the hands of the politicians.
Okay.
If the people say, well, the reason we don't have lawful government is because no one's participating in it, well, who's the no one? Well, it's me or you or your neighbor. Okay. And we're complaining about how government's out of control and how there's such dissatisfaction with Congress and the presidency and the judicial system. You know, the people are saying this system's absolutely broken. Well, I agree with that. It's illegal. It's unlawful. It was put into place in 1867, 1868. But we have a legal remedy to say, you know what? That experiment has failed miserably. Let's go back. Let's push the reset button. Let's go back to the foundation this union was created on, and put the federal government back in its cubby hole of 10 miles square minus what they gave back to Virginia. And let's get our country back, but it takes personal action, yes.
Okay. So Mandy is getting pulled into court. She has issues with, she's had issues with driver's licenses, right? Driver's license expired, I guess, or?
Yeah, she's basically had 3 issues. Okay. One is expired license, driver's license, expired tag, and not wearing your seatbelt. Again, these aren't your average, she's not a criminal out there trying to get away with criminal activities. Basically, what she's trying to do is if she recognizes the 12th state of the American Union as being lawfully created, and this state created by Reconstruction is not, then she has to decide whether she has to obey this new state that came into the Union. That is the predominant state that everyone sees out there. Our state, we have the laws, the revised codes of 1854, as amended all the way up through last week. Okay, we have a General Assembly and we're amending these laws. And there is no seatbelt law, but from the de jure state. There is no requirement to have a driver's license in the de jure state. There is no requirement to have a registered car in the de jure state.
And people still, they're able to drive? They actually have the knowledge and know-how to be able to...
It's actually absolutely unbelievable that people can not have that card in their wallet, and they don't just... It's not like, bumper cars out there. They're just hitting things and bouncing off of fences and just managing to stay on the roads.
Okay. So how is Mandy doing in this case? How's it coming along?
Well, I commend Mandy. This is, she's not trained at this. She's just an average person. She's just and these are can be fairly complicated issues. So she has to go in there, the way this system is, and...
Does she have an attorney?
Oh, she does not have an attorney. No. Here's one of the issues you've got is attorneys are officers of the court, of that court. They're officers of the court of the de facto state. Let me define de facto and de jure. You hear me saying these 2 words back and forth. A de facto is a government of fact, factually there, but not necessarily legitimate and lawful. Okay. A de jure state is a true and lawful government who has a right to exist, which may not be in operation, okay, because it's been replaced by de facto illegal government. Okay.
So the government that's in place now in North Carolina is de facto.
It is absolutely de facto.
And what you're participating in is de jure.
Is the de jure.
Okay.
Or de jure. There's
They both exist, but one is lawful. One is not.
Right. And according to the English legal system, which we are a product of, the British common law and where our foundation is, we have a right, we have courts, and courts are there to settle disputes. And you're supposed to have one side brings in their case, the other side brings in their case. You have a right to challenge what they say. They have an obligation to prove it. And a judge is supposed to be an impartial trier of fact and law. And so we've been having this, and now they're getting into bullying using the judge, who's supposed to be impartial. You're supposed to go into a court and feel good, right? You're supposed to go into court and say, hey, justice is going to reign here. If you got right on your side, justice, and the guy that's not the way the courts are. These courts they're political tools to bully people and to intimidate people into their political view. Much like, we look at the courts in Iran. They've got this Christian pastor they're wanting to hang because he won't convert. They're using the courts to bully him into a political view and a religious view. Our courts are no different here when you're dealing with Reconstruction. They are there to bully and intimidate people into believing it, even if you can see you have a right to challenge them, even if you can see the truth. There are facts, there are laws, there are violations of the Constitution. They're saying, no, they're not there, don't look there, don't bring them in here.
So how are they bullying Mandy? What exactly are they saying?
Well, let's just go through the process a little bit. She went into the district court. They found her guilty without ever addressing this. Again, the avoidance. They avoided this issue. Okay. She got into Superior Court. She puts in the challenge. Well, Superior Court's a court of record. Well, she went in Superior Court, and the judge actually, and this has only happened one other time in all the 10 years we've been doing this, 12 years we've been doing this, going into court, the judge says, she's challenging this jurisdiction here, and told the prosecution to answer her. Now, I'm going to have to change the topic up probably over to you a little bit, because you were actually there. Mm-hmm. You were there at the original case, and you actually heard what the judge said. And my recollection is, and the best information I have on it, because I was not there, is that the judge had the prosecution answer, caught him a little bit off guard, and then they proceeded to have an evidentiary hearing, bringing the police officer up, did you see her on the roads, and they cited the statute she'd violated. They brought in police powers. The state has police powers and things of this nature.
A lot of statutes. So you had a lot of books out.
Yeah, had a lot of books out, a lot of statutes.
Yeah.
Well, again, Mandy's not there to try the case. She's not there to try the statutes. She's there to challenge the creation of this state, being created by the Reconstruction Act. Well, the judge told the prosecutor that he provided insufficient evidence, and the judge gave him 2 weeks to answer. And so that's the way it was left. And then the prosecutor came back, and basically did a recap of what he said in court. But he did it in an order. He didn't provide any new evidence, as the judge told him to do. He went in and wrote an order for the judge to sign. And the order was an order to deny the motion to dismiss. They called Mandy's a challenge to jurisdiction a motion to dismiss. Well, it's not a motion to dismiss. It's a motion to prove you're lawful. If you're lawful, it's not going to get dismissed. It's not a motion to dismiss. It's a motion to prove you're lawful. Now, because they're not lawful, they know that if they go down that line, it will dismiss it. But they're the ones putting creating the words and the title of this document as a motion to dismiss. It's not a motion to dismiss. It's a motion to challenge jurisdiction. Well, here's another thing they do. I just got to put this in. Another thing that the prosecution did is they try to do trial by ambush with people who aren't well versed at this. He pushed the button at 4:21 in the afternoon with this order, and told her to be in court at 9 o'clock the next morning. So hoping that you have this person who's a neophyte, doesn't know what's going on, how to answer this stuff, will be caught totally off guard. So these are some of the tricks and tools they use, is give you as short a period of time as possible.
He didn't give her any time to respond.
No time, because she actually didn't get it. That's if she got the email then. I mean, how many people are sitting at their computer all day and got it? Yeah. I think she didn't get it till like 6:30, 6:25, 6:30 that evening. If you're going to be going to bed at 9 or 10, so you can get up and drive an hour, how much time do you have?
So she actually got a response together, though, right?
She got a response together. She has wonderful resources.
Okay.
And people that can help her with that, and that's good stuff. And we do everything we can to assist our citizens in these issues. So basically, the judge, grabbed hers, read hers. The prosecution hadn't even filed in with the court once she got there at 9 o'clock or whatever time it was heard. So it's like, she came in prepared. They weren't. The judge read it and said that he would prepare his own order, and put the case off till November 7th or something like that. And Mandy received a letter from the court earlier this week saying they had an order. And she got this order yesterday. Late yesterday, early yesterday, midday yesterday.
So this is that order, right?
And this is the order of the judge. And remember what we said all of our issues are. They want to bully. They want to avoid the issue. The issue we're dealing with is Reconstruction, the foundation of the state. And also a judge is supposed to be fair and impartial. He's supposed to deal with what the prosecution brought forward and say, well, the prosecution brought this forward. Because we've brought, Mandy has brought forward the surrender letter to the state of North Carolina, the Reconstruction Act, which annul the state. The Reconstruction Act in Article 5 of the Reconstruction Act coerces the amending of the Constitution. So you got violations of Article 5, Article 3, Article 4 of the Constitution in the Reconstruction Acts, which have never been adjudicated, and any person with even a high elementary school education could see that there's unconstitutional actions going on here, or at least it's not a resolved issue.
Yeah.
Well, the judge came back basically saying it's a resolved issue. That and I'm just going to try to read through this.
Okay.
And give you, this is the judge's order. And this is signed by Lindsay R. Davis, Superior Court Judge in Wilkes County. So if we want to know who are these people doing this, and put a face to it rather than well, they do this. Well, it's Lindsay R. Davis in this county. Now, I don't know who the DA was in this. I haven't been up there, so I don't know. But basically, he says this in the opening paragraph. He says, this matter came on for hearing during the September 12, 2011 mixed criminal and civil session of Superior Court of Wilkes County on respondent Amanda Lea Rose's challenge, and he puts that in quotation marks, to the territorial and in personam jurisdiction of the state to issue citations and exact penalties for 2 alleged violations of the by the respondent of NCGS, and he puts the codes there. Well, number one is she never challenged the jurisdiction to issue citations. So in the very first sentence, she didn't come in there and say, I challenge your authority to issue citations. That was never done. She challenged the jurisdiction. And if they prove the jurisdiction, she will say, I agree with your authority to issue citations. So again, he's changing the argument right there. So in the first paragraph, we already have an issue with this judge.
Okay.
Second paragraph, the respondent was present, appearing pro se. Well, no, she was making a special appearance. She did not, well, it says she was present rather than appeared. So that's potentially right. She was there especially to challenge jurisdiction. The state was represented by Assistant District Attorney Fred Bauer, so there we go. A hearing was conducted during which the state presented evidence, and both the state and the respondent were afforded opportunity to be heard in argument. In open court, the court announced its decision that the challenge was denied. Now, from every person I know that was there, and you were there, did the judge say this challenge, this motion is denied? To the best of your recollection?
No.
He did not say that.
So.
My wife was there. She said the same thing, that he did not say this. But we've got the transcript coming, and God willing, we've got a transcriptionist who got it accurate, and there is the outside possibility, I guess, that
we're
something
wrong.
was said. Yeah, we could be wrong.
Okay.
But he says that he denied the challenge and directed the DA to present a proposed order with findings of facts and conclusions of law, reserving, however, the court's authority to prepare its own order. So did he, again, you were a witness there. Did he say that, Mr. DA, I want you to prepare an order with findings of facts and conclusions of law for me to sign, and also I reserve the authority to prepare my own order? Do you recall those words being said?
All I remember is that I don't remember the exact phraseology that he used, but I remember the judge asking the DA to basically produce more evidence to, basically what we're asking for.
Right.
Essentially is what the judge responded with.
So we have right now, what we've got now is still a question of the integrity of the judge right now. Mm-hmm. That's a question. We're not going to go one way or the other on this point. I'll go into some questions on some other points here in a little bit.
Okay.
On September 22nd, 2011, the DA presented a proposed order to which the respondent objected, and the court advised that it would prepare the order. And then he has number one, nature and status of proceedings. This matter arises out of the issuance of 2 citations to the respondent by North Carolina Highway Patrol Trooper for violations of, and he cites the violations. The respondent appeared in district court. No, she made special appearance. It was not a general appearance. In district court, pursuant to the citation, and asserted a similar challenge, which was denied, after which the respondent was adjudicated responsible and assessed a monetary penalty and certain costs. The respondent appealed such disposition to this court. And then it says, item number 2, the nature of the challenge. It says the respondent challenges the territorial and in personam jurisdiction of the state of North Carolina. And again, right here you've got him assuming that they're the original, they're the jure. They're just going to make this assumption. Because you notice we use and we delineate. You have the de facto state and the de jure state, the 12th state, 39th state. He's going to get into a little bit of this, but right now he's saying that she has challenged the jurisdiction of the state of North Carolina, when it's really the congressionally created state of North Carolina. We're not challenging the creation of the original state of North Carolina. We're challenging the creation, the congressionally created state of North Carolina through the Reconstruction Acts. And she's challenging that, and presumably its courts and the authority of the officer who cited her. She appears to contend that jurisdiction does not exist because she is a citizen of the only real state of North Carolina, which she says was formed by the North Carolina Constitution of 1776, but was therefore unlawfully overthrown by action of the United States Congress in enacting and imposing, through coercion, the terms for readmission to the Union after North Carolina had seceded. Well, here's another concept, which is she addressed in there of her whole issue is this is not the readmission of the original state. This is the creation of a new state. So again, now you have the judge putting in purported facts that cannot be supported by history because they did not recognize North Carolina as seceding. He's in this sentence here says, well, North Carolina seceded. That got them out of the Union. And then the federal government put qualifications of what it took to come back into the Union and be readmitted. That's what it appears he's trying to show happened in history. Well, the war was fought that North Carolina's ordinance of secession was null and void. They never left the Union. They surrendered or at the end of the war and came back into the Union as if they had never left. They participated in amending the Constitution in 1865. Peace was declared in 1866. Congress recognized North Carolina as being back in the Union in 1866 when it sent the proposed 14th Amendment to them. So Congress recognized the original state of North Carolina as not ever seceding. So by him saying that it was for the terms for readmission after they seceded is a bold-faced fabrication of this judge. And again, let's look at another tool they're doing here. This is the argument the state should be giving, not the judge. This is now is the judge finding all the facts to legitimize. So and by putting it in an order, we don't have the ability to rebut it.
So the prosecution didn't say any of this.
The prosecution didn't say any of this. Never said this, never put it in writing, never did anything. This clearly shows that this court in Wilkes County, who Judge Lindsey R. Davis, he feels that what he believes is the law. What he believes are facts are the facts. The history he has is the true history, and no one is allowed to bring anything else in. Well,
so
that's
he's just assuming the history is exactly like most people think it is, or whatever.
It's an assumption, and again, he's denying us by not having the prosecution present this evidence. He's denying us the ability to rebut it. Okay, so that he can get a precedent on this, so that other people can say, yeah, it's already been denied by this court over here.
So people won't be able to bring it up again.
Right.
Okay.
He says she chastises this and other courts for not giving the premise of a meaningful hearing. I think rightfully so. She does. The premise, however, is a false one, with no basis in historical fact and lacking any semblance of legal merit. So now he's saying that there is no historical facts that support that a new North Carolina was created. There's no historical facts. He's saying it's a historical fact that North Carolina did in fact secede, and there's nothing to support that they didn't, except Abraham Lincoln saying these ordinances of secession are null and void. We're waging the war on the principle that they never left the Union. You remember they were, So what he is saying is that another country was created. If you believe in secession, you believe another country was created because these states seceded, called the Confederate States of America. And so instead, now you have the United States government conquering a foreign country under this judge's premise. If North Carolina seceded, well, now they're a foreign country, and they're conquering them. He says the contention that the state of North Carolina, under the authority of which the citation was issued, and this court exists, is not the lawful one of that name, is frivolous to the point of specious. and represents a waste of limited public resources, the court will not dignify the contention beyond the footnote that follows. And again,
wow.
so he's sitting there saying that this argument that the object of the war was for that these states had never left the Union. Mm-hmm. We have historical facts to say that's what they argued it for. He says that this doesn't exist. It's frivolous to even bring this stuff up. That two states called North Carolina, if the original state was readmitted, why was it vetoed by the president, this new state? In the surrender letter of the original state, he says, I surrendered the government to you under what I deem military duress.
So this, the last statement here is the court will not dignify the contention beyond the footnote that follows. Well, so what does this footnote go into?
Well, let me read it.
It's a pretty big footnote.
It's a big footnote, but let me read put this on. Again, this is a footnote that was not presented by the prosecution. The judge is prosecuting the case with this footnote and this belief system.
Okay.
Well, that was footnote 3, actually. And he said, the state of North Carolina was not formed by constitution. Its existence as a state was declared on July 4th, 1776, when delegates of the Continental Congress, elected by the North Carolina Provincial Congress, following express directions, signed the Declaration of Independence, which provided inter alia that these united colonies are and of right ought to be free and independent states, and they are absolved from their allegiance from the British Crown, and all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states they have full power to levy war, conduct peace, and contract alliances. As he looked at the North Carolina flag, if he looks at the North Carolina flag that flies in his courtroom, he'll see that there's a date called May 20th, 1775. Well, what is the date of May 20th, 1775? Because he's saying North Carolina wasn't created as a state by the Constitution in December of 1776, but by the Declaration of Independence, July 4th, 1776. Well, May 20th, 1775, which is on the flag that flies in his courtroom, is the date of the Mecklenburg Declaration of Independence, where North Carolina, representatives of Mecklenburg County, declared their independence from Great Britain. You know, we were one of the first ones, and we celebrate that by putting it on the flag, that we are a free and independent people based upon the violations of the Crown. So again, even this, what he says is just so settled, is not so settled. Okay? And he also has a footnote up here, footnote number 2, which comes from earlier, that she is a citizen of the only real state of North Carolina. They have footnote 2. It says, she refers to the state as the 12th state, and to the state existing after such coerced readmission as the 39th state. And again, he's saying it's the coerced readmission, so that's another falsity that he's putting in his footnote. He says, however, the state of North Carolina has never lost its statehood. See Midle versus Ellington, 134, North Carolina 131 at 155. It says, we may assume that the state of North Carolina has never at any time from its earliest existence lost or forfeited its statehood, its political integrity, nor has the allegiance of its citizens or the officers of the state been changed to any other government except insofar as the state occupied relations to other governments. This is just a statement of a court. And they're operating off of the principle of, well, the Reconstruction Acts have never been adjudicated, but they're putting in this principle that the state of North Carolina has never lost its statehood. Well, the Reconstruction Act reduced it to a territory. What do you call that? Kicked it out in 1867. And said now a new state, it lost its statehood. Okay? But I contend that he's right. It never did lose its statehood, because the Reconstruction Acts were unconstitutional, and what they created, this fraud that's in place now, is illegitimate, and we have a right to participate in the original state.
So he's arguing your
He's
case.
actually arguing on our side with this one, but again, by putting it in an order and saying, and putting all this flamboyant wording at the front end of it, that I won't dignify you with an answer because it's so frivolous and without merit. No, he puts all these words in front of it, and then comes to this, and wait, this is not settled facts, historical or legal, lawful.
I see.
And again, they're denying us the right to rebut this stuff by putting it in an order. Okay, so they go on. Let's go to page 3 of his order. He says the respondent argues that the state has the burden of showing beyond reasonable doubt that jurisdiction exists, citing State versus Batdorf. In that case, in which the defendant disputed whether the alleged crime was committed in North Carolina, the Supreme Court placed the burden of proving jurisdiction in a criminal prosecution on the state, overruling prior authority. And that's what we cite. But he goes on. He says, however, the issue there was one truly of territorial jurisdiction, and the rule adopted in Batdorf applies only where the facts supporting the state's allegations to territorial jurisdiction are in dispute. It has no application where, as here, the challenge is the theory of jurisdiction. And it says, see State versus Jure. It says, in the latter case, jurisdiction is a question of law. The disputed facts in the case set out in the following section. He says that Batdorf deals with territorial jurisdiction. Well, that's what we're dealing with. Who has jurisdiction over the soil? Who has lawful jurisdiction over the soil of North Carolina? The original state or the 39th state, the one that created by the congressionally reconstructed state? You know, who has lawful jurisdiction? The Constitution of the United States says you cannot create a state within the jurisdiction of another state. So we contend, we go with him, we say that the original state of North Carolina never lost its statehood. It's always been there. The 12th state, for the freemen of North Carolina, never lost its statehood. And so the Constitution says you can't create a state within the jurisdiction of another state. Well, it never lost its statehood. How did Congress create a new state and say it has authority over this soil? Now we've got two states, two bodies, two different entities claiming jurisdiction over the same. Now, again, their argument is, well, this was just a readmission of the old. So these are clear constitutional violations that he just wants to arrogantly pretend these are frivolous matters. We don't know what we're talking about. And we're saying, hey, give us a shot. Have the prosecution answer. Give us 30 days to answer the prosecution. Mm-hmm. Don't just write these orders up and say you can't and you can't question it. I'm just going to talk down to you. This is judicial bullying. This is judicial tyranny. I'm going to go to the end of this because he goes, his conclusions of law, basically he goes, his undisputed facts, or again, our issues are, and Mandy recited it, was our issue is, are you a lawfully created state? We're not dealing with the merits of the case on who's driving on the roads or whatever. Yeah. So he does his undisputed facts. On October 21st, 2010, she was given a ticket for not having her seatbelt on, blah, blah, blah. So he does not address Reconstruction. Reconstruction is not addressed in the undisputed facts. And there's lots of undisputed facts in Reconstruction that they refuse to recognize. And then he gives his conclusion of law. He says, Wilkes County is a political subdivision of the state of North Carolina. And again, our issue would be, which state of North Carolina? It is the congressionally created state. Does it have a lawful foundation? Oh, they're avoiding that issue. It says, the statute which the respondent is alleged to have violated is constitutional and a valid application of the state of North Carolina's police power. Well, again, we stated before that we believe that a lawful state has legitimate police powers. The issue is, are you a lawfully provable state, which they avoid? Yeah.
It looks like they would, with such repetition, they would understand what we're trying to ask of them.
Oh, I think they understand totally. The issue is they know they're illegal.
Okay.
And so what it boils down to is to what limits will they go to abuse the people, to intimidate the people, to put them at the most disadvantage by giving them the least amount of time, by giving them no opportunity to rebut, and no opportunity to rebut because the state put nothing forward. Mm-hmm. To what limit will these people go to avoid proving they're lawful? All they got to do is prove it one time. Yeah. Not just claim it, not just put these orders out. Prove it.
Beyond the shadow of a doubt.
Beyond a shadow of doubt.
Okay.
He goes, item 3. The court has jurisdiction over the person of the respondent and the subject matter. Okay? This is a huge issue. If you look at the body politic of the 12th state, it's the freemen of North Carolina. The body politic of the supposed readmission of this new state, or the original state, is any person born in the United States. Well, is the freeman of North Carolina and any person born in the United States the exact same body politic?
So that goes into the 14th Amendment.
This goes into the 14th Amendment because you looked at who can vote and who could vote in this other state, which he says was just a readmission of the old. It's a total change of body politic, total change of laws, and he's saying that they're identical. He goes on and basically says that the venue is proper in Wilkes County and the respondent's challenge to jurisdiction has no merit. And he puts a footnote number 4 on it. It is, in fact, frivolous and an abuse of the liberty provided by the North Carolina Constitution, e.g., for example, Article 1, Section 18, the laws of the very state that she contends does not lawfully exist. The General Assembly has provided means to sanction such waste of states' limited judicial resources in civil matters and should consider similar means in criminal and infraction matters. Okay, so now you have a threat. In other words, we've got legal arguments rock solid they can't answer. And they're doing everything they can to avoid it, and now you have an impartial judge bullying someone out of the exercise of their political rights. They're trying to intimidate her out of participating in a lawfully created, provable state government, and say, we will fine you. We're going to consider doing more mean things to you. If you bring this issue up, you need to accept this state as legitimate. And don't question it.
Even though we haven't proven anything.
Even though they've proven nothing.
Okay.
These are just his wishes. All this judge has put down is what he believes, with no expert witnesses.
So most people would look at this and they would cite this judge's order, and they would say, well, I guess you can't go any farther.
Well, and that's the issue.
So what exactly is, what is the next step exactly?
Well, this is a judge's opinion. Okay. He made a ruling that this is a frivolous issue. And so you have what's called an interlocutory appeal, where you can appeal not the case, because again, we're not even dealing with the merits, whether she was driving without a license or driving with her seatbelt off. That's not even on the table yet. The issue is, are you a lawfully created state? The judge has ruled clearly we are. It's frivolous to even question us.
So you've got Mandy going into court. I was there. There's been a few people participating, a few people showing up to court. I'm assuming this would have to be, you're going to have to get a lot more supporters. To really understand this concept and to take time and to go in and to support this, right? It's going to have to be it's going to have to be bigger.
It is,
isn't it?
And the political landscape of America is up for grabs. You got the Occupy Wall Street people, they want to go in their socialist directions. You got the Tea Party who want to go back to a foundation. You got the Republicans, you got the Democrats, you got the Hispanics who want to get their views in and become citizens. You got everyone vying for their bit of the political pie here. And they're motivated. And I'm here to say they're going to take it. We're going to go, we have a right to get our country back, a legal right. And if we can't get passionate enough, if we can't get up and show up these cases and to start making a difference, then we're handing it over to anybody else who's passionate enough to take it. It's our right to keep America and get back to our foundation.
There's a lot of passionate groups out there today.
There's a lot of passionate groups, but we got to get them focused on how we lost this country.
So the first thing people need to do is they need to educate themselves.
Absolutely.
This is a controversial topic. It's obviously there's a lot of issues here. Why is she going without a driver's license? Why is she doing this? And all these different issues that are, it's very controversial. So people need to first do the research.
Absolutely.
Obviously, they need to learn. And so you do talks on this. You'll go pretty much anywhere to
I'll go anywhere. I travel.
You have a little hybrid car that you travel.
I've got a hybrid car I travel in. We're doing a talk up in Virginia.
Okay.
Here in a couple of weeks. I do talks in Maine. I've done talks in Vermont, Georgia, South Carolina, Tennessee, Virginia.
Wow. Okay. Do you charge for these talks, or how many people usually attend with these things?
That varies wildly. Anywhere from 5 to 70 to probably maybe, let's see, I'm trying to think. Yeah, about 5 to 70. Average is about 15 or 20.
Okay.
So it's not huge crowds we're spreading this to, and that's what we're trying to get to. I go out there to try, I try to make this as cost effective as possible. I'm not out here trying to get wealthy off of it. I do want to cover my gas and try to maintain something of a living. But the passion is to get the information out. If you've got the desire, we can work out something.
Okay.
To get a talk on this.
All right, now, John, there's a lot of people out there. I hear this a lot. I'm too old. Okay, I've got a vested interest in the current system. I've paid my taxes. I'm collecting Social Security. I can't just let go of all that and become a citizen. Now, that requires a lot of sacrifice. And a lot of people don't want to do that. What can they do? What can they do to help?
Well, that's an excellent question, because you're dealing with different personalities, different needs, where people are in life. We're not asking people to become martyrs and just throw away everything and hop on board this thing and go broke at it. Different people's threshold of what they're willing to do are different. Some people say, me just learning about this, like I'm really crossing a line. Just learning about it, just sitting in the room listening to you is really pushing my edge. Mm-hmm. Okay, and then you got people who say, you know what, I need to look at that. Look a little further, because they got wives they've got to deal with. Some of them have young children they've got to deal with, and they've got to balance all this out. And then you got people who are like Mandy, who's willing to just jump in it full-fledged. Let's go out there. Okay, so you got a range of people who want to do something that's just as wide as you can get. Well, we need people just to show up at court case. Maybe the degree of support is showing up at a court case just so they see numbers. Okay, maybe it's financial help. Maybe you've got money and you don't have time and you desire, but you could financially help us out.
Well, there's a lot of expenses that go into these
There's a lot of
cases,
expenses
right?
in these court cases. $400 transcripts, $400 or $500 filing fees.
Wow.
I mean, it just piles up really quickly on these things, and getting court reporters in a district level. So financial, if you can help financially. We've got, you got, helping
people can do that on the website.
Writing articles about what we're doing.
Okay.
Maybe you want to write about it, report it. Maybe your degree is, what, I would like my neighbors to hear this. John, would you come over here and speak to my neighbors, because I can't articulate it. Mm-hmm. Because you know what it's like when you go hear a good sermon or hear a good speech. It was really good. Well, what did they say? And you just can't articulate what you heard. Okay. And that's real common with this topic, is people can't articulate it or troubleshoot it, question answer it. And I'd be glad to start doing question answers. If you've got someone who who just says these guys are dead wrong, and maybe he's a lawyer, I'll debate them. Mm-hmm. Okay, it's real easy. Heck, we got a $10,000 reward out for someone who can sit there and prove that the present state is lawfully created.
So this is a challenge you've given in your past
challenge I've given.
Presentations. Okay.
And so if you've got someone who wants to take on the $10,000 challenge, we'll sit there and debate them. But they got to bring in facts and law. We would love to have everybody hopping on board, but we know that's not practical.
Not everybody can be on the front lines.
Not everybody can be on the front lines. We need people, doing office work. We need people. We need to build a grassroots organization, and we've got a grassroots organization that's actually working right now. And we would love to take some of the work off of some of these people that are doing a lot of the work out there. Come on board and help us. You can get behind the scenes. You can get in front. Show up at a rally. We're going to start doing rallies. We're going to be in Raleigh here next year. Just things of this nature. Okay.
Well, John, thanks a lot
Thanks, Cliff.
for this interview. This is very good, and hopefully this is going to get information into the right hands, and hopefully more people will come on board and support this.
Well, and it's just important. I mean, if once you see the truth, you can't go back. I can't go back, at least until someone can say, John, you're wrong, and here's why. And when they avoid it, I can't go back. I can't stop doing this. And I think that's the passion that gets in most people who see this. It's like, once you see the truth, how do you go back to the deception? And so,
yeah. Well, this country, it has been a great country, and we want to stand up for our rights, and we want to stand up for freedom and liberty.
We want to stand up for our Constitution. I am absolutely 100% pro-government. But I'm pro-lawful, provable government.
Well, thanks a lot for joining us. I know this has been a lot of information. Visit the websites americasremedy.com. Have John out to give you a presentation. He can do hour-long presentations as well as full weekend seminars, and there's a lot of information to cover. So just if you want to fill up your brain with some information, he's a good person to contact. Also visit ncrepublic.org. see what we're all about, see some of the past court cases, a lot more videos and information there, and contact us if you're more interested, if you want to learn more. Thanks a lot for joining us.